Hey guys, welcome to my channel. Today's case follows a divorce hearing unlike anything you've probably seen before. What begins as a routine family court proceeding quickly reveals a shocking story of violence, survival, and the legal consequences that follow. With the husband appearing from jail and the victim recounting life-changing injuries, the judge is faced with decisions that will affect property, custody, and the future of two young children. Stay with us until the end to see how the court ultimately rules.
We have confirmed that he's being housed at the jail there. All right, this is the Tessa Clarine Trotter Mowell versus Zachary Lee Mowell, and it is for final hearing on the divorce action that's been filed in this case. And Mr. Mowell, you're representing yourself pro se. There's no, I don't believe there's an answer that's been filed.
There has not been an answer filed, Judge.
Right.
Due to the fact that he is in jail, we did not file a default, but it will be similar to a default as we present.
Our appellate courts have ruled that even though you're incarcerated, you have the right to have participation in this action, but because you have not filed an answer, you will be limited to observing what takes place at this point in time. Right. Ms. Duke, you wish to put on your proof if you want to bring, are there any other witnesses?
There are no other witnesses. It's Ms. Mel today.
Can we bring Ms. Mowell for her testimony up since she's in a wheelchair to the
Absolutely.
witness block? If you'll come around, Ms. Mowell, we're going to ask you to.
If you would, please state your full name for the record.
It's Tessa Clarine Mowell.
Ms. Mel, you are currently married to whom?
Zachary Mowell.
Okay. And Mr. Mowell is currently incarcerated, is that correct?
Yes.
Okay. And is he incarcerated due to the, and you just say yes, on July the 1st of 2024, he attacked you, is that correct?
Yes.
Okay. And as a result of that attack, you almost died, is that correct?
Yes.
You have been rehabilitated, is that correct?
Yes.
Okay. And is this in fact Mr. Mowell here on the video screen?
Yes.
Okay, and he is in fact the one who attacked you, is that correct?
Yeah.
Due to the attack, are you, have you incurred significant medical bills?
Yes.
Okay, significant time away from work?
Yes.
Okay, significant time away from your sweet boys?
Yes.
Okay. And have you had to go through very painful physical therapy?
Yes.
You had 9 stab wounds, is that correct?
Yes.
Okay. And when they transported you, they had to transport you on your stomach, is that correct?
Yes.
Because of a knife that was in your back.
Yes.
Since that time, have you, were you also set on fire on that date?
Yes.
Okay. But you survived those injuries.
Yes.
And are you asking the court to consider the things that we've just gone over in awarding you the assets in the marital estate?
Yes.
Okay. And the only assets in your marital estate due to the fire at the residence are the residence itself, which is in a dilapidated state right now, is that correct?
Yes.
And 2 vehicles, which the court has already given you permission to sell, is that correct?
Yes.
Okay, the truck and your vehicle. You've retitled those vehicles at this point in time, is that correct?
Yes.
And your vehicle, the car, has got a lien on it still, is that correct?
It is.
Okay.
Yes.
And you're working to get that paid off.
Yeah.
Okay. The home has still got a mortgage on it, is that correct?
Yes.
In a perfect condition, how much would you tell this court that that house is worth?
About 300.
Okay. And your home, did homeowners deny your homeowner's insurance as a result of the fact that that your husband set fire to the home?
Yes.
Okay. Are you asking this court to take that into consideration when he's awarding the marital estate, when he's dividing the marital estate?
I'm sorry, did you say the insurance company has denied the claim for insurance because it was an intentional fire by?
Because it was arson. Yes, sir.
What company was that? What was your insurance company?
I believe it was Allstate or State Farm. I
I
can
want to
look.
say State Farm.
Doesn't really matter, I was just curious.
I believe it was State Farm, Judge. And at this point in time, the house and the condition that it's in, is it worth probably less than what's owed on it?
Is it worth less?
Is it worth less than $180,000 because of the fire that was set on the inside of it?
I want to say that.
Okay. And do you know about how much in damage, how much it's going to cost to repair that home?
About 50 to 70,000.
And after that, there probably will be $25,000 to about $30,000 in equity. Is that correct? Okay. Based on the fact that Mr. Mal is in jail and looking to be sent to prison after a subsequent criminal trial, are you asking this court to award you all the equity in the marital residence and all of the value for the vehicles as your child support and any spousal support that he may be required to pay?
Yes.
Okay. Prior to him going to jail, was he earning approximately $60,000 at Dial Tile?
He was.
Okay. And you say approximately because that is he was never very forthcoming with what he was making. Is that correct?
Yes.
Okay. And you believe you would be entitled to more than just the equitable portion of the estate for child support purposes, but you're asking the court to award you the house at this point and the vehicles. Is that correct?
Yes.
At this point in time, do you know, was Mr. Mal honest with you about anything he was doing with retirement? Do you know if he has retirement?
I just knew he just started late.
Okay. And are you waiving your interest in any retirement at this point? To his retirement? He had like $300 in it, is that
Yeah.
correct? Okay. Are you asking that the court allow you to keep your retirement?
Yes.
Okay. Is there anything significant in your retirement at this point in time? Okay. Now, there was a GoFundMe and some other monies that you collected due to your injuries. Are you asking the court to award those to you
Yes.
as having occurred after the fact and they were raised specifically for you, gifts to you? Okay, they are separate property. They are not his property. Is that correct?
Yes.
Now, on to the very most important thing in this trial today are your children. Are you asking that this court awards you sole custody of your minor children?
Yes.
Okay, and that is Jackson and Carter Mal, is that correct?
Yes.
Okay, and are you asking that this court maintain there is a order of protection in place based on the injuries that you incurred? Are you asking this court to put down a permanent injunction preventing Mr. Mal from having any contact with you or your children?
Yes.
Okay. Are you asking that pursuant to the parenting plan that you be awarded all holidays, all visitation, all the tax deduction, that if Mr. Mal were to get out, are you asking that Mr. Mal be required to carry a life insurance policy on himself for the benefit of your minor children?
Yes.
Okay. Are you asking this court to make sure that if Mr. Mal does get out, that Mr. Mal start paying child support for these minor children?
Yes.
Okay. Is there anything else you'd like to ask this court to award you as far as the children are concerned? Are you asking the court to prepare a separate order regarding what else we spoke about?
Their last names.
Okay. Are you asking that their last names be changed?
Yes.
Okay. Are we living in a very small community where that Mr. Mal's name is identified as being criminal in nature, and you're asking that your children be absolved of that?
Yes.
Okay. And you're asking that your children be named to your maiden name, is that correct?
Yes.
And are you asking that your maiden name be restored at this point in time?
Yes.
Okay. And for purposes of anonymity, we're not going to say your maiden name out loud, but the court's got it in their file. Okay. Are you asking that these minor children also drop their they've got 4 names, is that correct? 2 middle names for both of them?
Just the first one got the 2.
Okay. Are you asking that they drop the name Lee that is synonymous with Mr. Mowell?
Yes.
Judge, that is our proof.
All right. Ms. Mowell, my understanding is that because of the assault on you by Mr. Mowell, that you sustained 9 stab wounds and that you were then, he set you on fire as a part of this attempt on your life. And I see that you're in a wheelchair today. Are you confined to a wheelchair or are you able to get around?
I'm confined. I can walk just a little, but it's everything I have.
Okay. All right. Well, it is unfortunate that we're having to have this hearing at all, but I will hear from any other witnesses. Do you have any corroborating witnesses?
I do. I have one back here.
Let's just let Ms. Mowell stay where she is, and then we'll bring up the corroborating witness.
Well, and if you need to, Judge, I've got Ms. Roberts. She can cooperate also if you need an extra one. But I'd
So
love
we're
to
going
put
to
her
place
under-
Ms. Roberts
I'd
under
love to
oath
put her
as
under
well.
oath.
To be under oath, I'm limited to the testimony.
Well,
Just
now
so that there's not an issue.
I think I will be the judge of how limited we're going to be with questions. All right, both of you raise your right hand. Let's place you under oath. All right, Ms. Duke.
Ms. Roberts, did you hear everything that was said and everything that was testified to? And so you know everything that Ms. Mowell has said today to be true and correct to the best of your knowledge? And you think that it's in the best interest of the minor children to have no contact with their father and for Ms. Mowell to be awarded the marital estate? It's a mess.
It's a mess.
If you would, please state your full name for the record.
Timothy Wade Trotter.
And Mr. Trotter, you heard all the testimony today, is that correct?
Yes.
And is it true and correct to the best of your knowledge, everything that's been testified to today?
Absolutely.
It's in the best interest of these minor children to never have contact with Mr. Mowell again. Everything else that Ms. Mowell testified to, she's entitled to the marital estate, and you've observed the condition of the marital residence and of the vehicles. Its arrest, and currently, they're still all devalued to some degree. The division of the marital estate is equitable, having been awarded to Ms. Mowell. Judge, that's our proof.
All right, Ms. Mowell, you can come back if you'd like. The court finds, based upon the proof in this court, that the wife is, or that the plaintiff wife is entitled to a divorce on the grounds of an attempt made by the husband on her life by means of malice, including the stabbing and setting her on fire. And that's a ground set forth in TCA 364107, subsection 7. It obviously constitutes the inappropriate marital conduct, but I think that prior finding is more appropriate. The real property that's located here has de minimis value at the present time because of the fact that it's in a state of disrepair. It's going to require expenditure of monies before it will actually be marketable in any event. The law requires that the court, in considering a division of marital property, to make that division fairly or equitably without regard to fault. And so I am stating on the record that I am making this division of what I consider to be a fair division without regard to the fault of Mr. Mowell and his attempt on the life of his wife. But because of that attempt on her life and the injuries that she has sustained and the damage to the real property that has been occasioned by Mr. Mowell's actions, according to the proof in this case, the equitable distribution of property is, in my opinion, favors the wife. And for that reason, I will award her all of the equity that may exist, if there is any, in this real property. She's awarded the title to the property, free and clear of any claims of the husband. Of course, that is subject to the mortgage interest. And I also would point out that part of my consideration has also been the fact that his actions, as proven by the proof in this case, led to the denial of insurance coverage on the damage to the property. Go ahead. And the two vehicles that were involved in the case represent the only other assets that the parties had. And for that reason, because of the medical expenses that Mrs. Mowell has incurred, it is my opinion that all of those assets should be awarded to her to help to compensate for the medical expenses and so forth, and the damage to the real property that were occasioned by Mr. Mowell's conduct.
But we're also asking for attorney's fees. At this point in time, I can submit an affidavit.
Submit your affidavit, but I believe she would be entitled to attorney's fees as well. He will be awarded the retirement account in his name only. She will be awarded the retirement account in her name only. Any monies that were acquired by the GoFundMe account that was set up following this event that led to her injury and hospitalization will be awarded to her as her separate property. Is there any other asset of property that I have not dealt with?
There isn't, Judge. They're young and had not acquired much.
All right. Then moving to the issue of the custody of the minor children, clearly Mr. Mowell is facing an attempted first-degree murder case charge that is yet to be heard, and he's presumed to be innocent of those charges under the criminal law. But in this court, the court finds that the proof is established for, at the lower burden of, by preponderance of the evidence, that he did in fact attempt to take the life of his wife. And for that reason, the court finds that she should be granted sole and exclusive custody of the minor children. She will be designated their primary residential parent. I do not set any sort of visitation for Mr. Mowell whatsoever at this point. If Mr. Mowell in the future is released from custody and in the future chooses to try to have a relationship with his children, he will have to file something with the court to establish some sort of visitation. And for that reason, I'm not delineating any type of holiday or any other visitation. The children will be with Mrs. Mowell exclusively. While I can only extend an order of protection for 1 year and then renew it year to year, I can issue a permanent injunction, and this court will issue a permanent injunction against Mr. Mowell, who is, I'm sure, under bond conditions anyway under his criminal case. But that permanent injunction prohibits and bars him from any contact, directly or indirectly, with Mrs. Mowell or with the minor children. Again, that would defer to any future order regarding any sort of contact that a chancery court or domestic relations court allows contact with the children upon his release from custody. But at the present time, he is not to be allowed to have any type of custody. The proof in the case is, as I understand it from the file at least, that the children were present during his assault on Mrs. Mowell and tried to talk him out of doing the things he was doing. That's set forth in the complaint itself. And because it was a sworn pleading, I will take that as, and take notice of that. So based upon those facts, I don't think it's appropriate for him to have any contact with the minor children at the present time. Again, if he's released at some time from in the future or found not guilty for some reason, then he has the right to come back into court and to seek some sort of visitation with the minor children. The issue of child support is simply reserved. He obviously at the present time is incarcerated, has no ability to pay any sort of child support, and the court finds that a name change is in the best interest of the minor children as was requested. Based upon all of those factors, those are my ruling. Anything that I failed to address?
Judge, that is everything.
All right.
I did not bring a final decree over, not knowing how this would be handled
You'll
today.
prepare the final decree and submit it along with your affidavit of attorney's fees.
I will, thank you.
All right. So this case is set for final hearing on Thursday, and you filed a motion to set a designated, a spot for visitation
Two things in my motion, Judge. Number one, I'm dealing with a pro se individual, as you know, if you remember these hearings, and a difficult person to speak with. And I've not gotten any update with any of my discovery. If you'll remember, he had a counselor that came in, that he was seeing, came in on Zoom, said he was okay for unsupervised visitation after I cross-examined the counselor for a little bit. It was apparent that the counselor didn't know a lot of the things Mr. Graham had told him. So he came back and said, no, he should only have supervised visitation. I have no other reports. Ms. Smith tried to contact the counselor. I don't know where she is with that.
The remedy is if he hasn't supplied you with updated information, then that information would not be admissible in court.
I want to make sure with the court, I explained it to him this morning when he was present, and we did have a chance to talk outside. That was one of the things that I was requesting, was to make sure, and specifically the counselor. If the counselor walks in or says, yeah, he's okay on Thursday, I mean, I need some time to investigate that. So that's going to be kind of an issue at that time. But I wanted to make sure that he knew to update his discovery since he was pro se. And then also with this order, we've gone round and round. I know Ms. Smith sent a GAO report in. There's been some issues as to where to conduct this visitation. We did find a supervisor. There was somebody that agreed to do it that was willing to travel to his area to do anything. He was demanding that it be at his home, and we didn't feel comfortable with that. My client didn't. I felt like we were okay with, saying that. I spoke with Ms. Smith put down a kind of a timeline on April the 10th or the 11th. I spoke with Ms. Smith. I felt like she kind of supported our position. I want to make sure, kind of bounce it off somebody, that we weren't being, hard to deal with here. But he has a trailer by the river. Apparently, according to Jeff Ford, there's another woman living there now that has a child that is now pregnant with his child. He doesn't deny that. I think that's going to come out at the final hearing. All that being said, we just didn't feel comfortable with him, carrying a gun to church at one point and doing some of these other things, and some of your findings, even in this second order where he brought us back to court. Did not feel comfortable staying, at that camper with a new supervisor that doesn't know him from Adam. And basically, we said anywhere else, but he wouldn't agree to it. And I thought, well, I know what the judge said. I know how the judge looked at everybody when he talked about getting him some at least supervised visitation. And I still wanted to stay on the good side of that look from Your Honor and not get on the bad side of it. That was why I filed this today. I'll hang around if he gets on Zoom, try to work something out between now and the final hearing, or try to work something out where we can.
Final hearing being on Thursday.
If that's what he wants to do. I just put that in there to make sure that, I was explaining this to the court. If there was some way to do it between now and Thursday, I would. And that I'm not trying to be.
Well, if you want to wait around and see if he comes in on Zoom, but, pardon? Okay. Ask him to start his camera. And Ms. Smith is the guardian ad litem, and we don't have her here today. Is that correct?
We do not. She has filed a GAO report.
We are here on a motion that Mr. Holly has filed. Have you seen that motion?
I have seen said motion.
All right. Then, Mr. Holly, if you want to argue your motion, I'll be glad to allow you now that he's with us.
Judge, the first thing in the motion is the discovery. Mr. Graham is pro se. He and I had a chance to talk out in the hallway a little bit when he was here this morning. The gist of this is I filed discovery. I'm entitled to that being continuing as far as the answers go. We've got a final hearing. I've not received anything from Mr. Graham whatsoever regarding, in particularly, his counseling. And again, that counselor was saying, his own counselor, that it was to be supervised visitation. And if that's going to change, obviously, I need to know that. I know Ms. Smith tried to contact the counselor. Mr. Graham told me that this morning. He's right about that. But I just don't know what the current report from the counselor or what he's expected to testify to, which are all things that I request in discovery, along with everything else that's in discovery I'd like to have updated. And that may be an issue between now and Thursday, depending on what he gives me. But this was the first opportunity I've had to come into court with your calendar and mine and whatnot before this final hearing, when I'm trying to get prepared for this thing, to kind of give him a heads up to make sure that he knows to update his discovery. He is pro se, and then that he does so. Secondly is the place for visitation. We have, and I've got emails I could give to the court. I'm going to save them if the court allows to the final hearing. Mr. Graham has been very persistent that it be at his home. He will not agree to go anywhere else. We've agreed to, as far as the mother's concerned, to go anywhere else other than his home. We didn't feel like the home was appropriate, given that what we know from Mr. Ford now, that there's another lady there living there that's pregnant with his child, got another child there. And in particular, when you look at the order from the 7th day of February, it kind of backs up exactly what the initial preliminary hearing findings were. The court finds that the father still has animosity and anger. His attitude and demeanor today in court speaks volume about his particular state of mind. Father is still not able to control his anger, and this is apparent from his testimony and sarcasm from the bench. It may take a while for the father to get over his anger. He shall continue counseling with Jerry Smith for treatment. That's the name of the counselor. With those involved in the history of him basically carrying a weapon into church and things of that nature, I didn't feel like it was appropriate for a counselor that didn't know anything about this case from Adam to go out there to his home and get involved with some of that. My client didn't feel comfortable with the child being out there in the middle of that situation to begin with. I bounced that off Ms. Smith. From what I gathered from her, she was in agreement with me. In that situation, she's prepared a report for the court. We're willing to go anywhere. And I know it's short notice, but if he wants to get with the counselor, I know she's emailed a couple of times, and get some sort of supervised visitation, we're here for that. I know the court was wanting him to have some supervised visitation at that point, but that's kind of the box that we've been forced into at this point.
Mr. Grammond, you're representing yourself, and as a result, the same rules apply to you as apply to anyone that has an attorney. One of the rules in civil procedure is on discovery that you must seasonably supplement your answers to discovery before the final hearing if there are any changes to any information. And you understand that the remedy for failure to comply with the discovery is that I would be required to exclude any evidence that you might find that you would want to introduce that you've not given to Mr. Hawley notice of that evidence or copies of that evidence. So is there anything that you have, is there anything to supplement about your discovery responses at this point?
I'll file updated responses with Mr. Hawley.
Well, you're going to have to do that by tomorrow and email them to him in order for even a chance of your final hearing to go forward on Thursday. Mr. Hawley has a right to see that information beforehand, and then if it is involving significant changes to the situation or significant information that was not previously supplied, then Mr. Hawley's going to be in here asking to postpone your trial. So I would suggest you get that information to Mr. Hawley by close of business tomorrow. That is Tuesday at 5 p.m. And you can email it. You know his email address. Email that to him, and then we'll see whether or not we're able to go forward on Thursday. But right now, I don't see any reason to consider the issue regarding the change of or designation of an agreed spot for visitation, because we're going to have some sort of a hearing on Thursday of this week anyway.
Yes, that's fine. Thank you, Judge.
We will see you all on Thursday, and we'll determine whether or not the case can go forward in full or whether or not we're only going to be dealing with the visitation aspect.
Thank you, Judge.
Thank you.
This hearing serves as a powerful reminder that family court proceedings are not only about ending a marriage but also about ensuring the safety, stability, and future well-being of those most affected. Throughout the testimony, the court heard detailed evidence describing a brutal attack that left the wife with life-threatening injuries, extensive medical treatment, permanent physical limitations, and emotional trauma. The judge carefully considered how those events impacted every aspect of the family's life, including the condition of the marital home, the financial losses caused by the fire, the children's emotional welfare, and the husband's incarceration. Although the criminal charges against the husband remained subject to the criminal justice system, the family court applied the civil standard of proof and determined that the evidence supported granting the wife the relief she requested. As a result, she was awarded sole custody of the children, ownership of the remaining marital assets, the proceeds from her personal fundraising efforts, and a permanent injunction prohibiting any direct or indirect contact by the husband. The court also ruled that any future visitation would require the husband to return to court and demonstrate that such contact would be appropriate and in the children's best interests. Ultimately, this case demonstrates how family courts balance legal principles with the facts presented, focusing above all on protecting victims and safeguarding children when making life-changing decisions. If you enjoyed this video, don't forget to like, comment, and subscribe. Thanks for watching, and I'll see you in the next video.